like to introduce our speaker for today. He is Shandip Shah, who is the Principal and Managing Director of Balance Consultancy, who are based in Stanmore. Shandip has been an estate planner for over 7 years, and prior to this, has some 30 years of experience in banking and pharmacy retail management. He has clients all over England, but the main concentration is in London. He chairs the Middlesex and West London Regional Society of the Society of Will Writers, and is also on the National Professional Standards Body of the Society of Will Writers. He is passionate about this topic and sees his role as vitally important in educating the public at large, as death, as you know, is inevitable, and the likelihood of the loss of mental capacity is also very high. He is a trustee of a major charity promoting humanitarian work. So without much ado, over to Shandip.
Thank you so much, Rumit. So just give me a few seconds and I'll put my slide on. Okay, I hope everyone can hear me well. And like Rumit said, the sentiments, I hope everyone is keeping well, keeping safe in these very unprecedented times. Jai Jinendra, welcome, namaste to all of you, and for giving up your time this morning to listen to this presentation on wills and powers of attorney. So there will be two separate presentations, one on wills, one on powers of attorney. So let me start straight away on the wills one. So all about wills. Before I kick off the technical side, today is about you. It's not about me. It's not about CAT8. Today is about you to get information, to be more versed in this area, even if you have got wills, power of attorneys in place, and hopefully you'll be able to learn something new you can share with your friends, family, etc. So take it in. This is not about us at all for today. So let me get over the bad news first. One day, each and every one of us who are born will die. It's a fact of life. The day we are born, there will be an end game to that, and there will be a day we will pass away. However, none of us know the date beforehand. How amazing would that be if we did know it? But we don't. It's a fact of life that we are not going to know what day, when we are going to pass away. However, it is very certain that it will happen. It is so certain, yet why do we never plan for it? I'm not saying everyone, but in this country, roughly around 60% of the eligible population do not have a will. Staggering figures, really, but there are reasons. So what could be the possible reasons? Many people don't want to think about the fact of death. They don't think they will ever die. Very understandable, people don't want to talk about it. I have had cases where people have said to me, look, if we plan for it, it's going to happen. Very contradictory statement, but it will definitely happen even if you don't plan for it. It's not a great subject to talk about. It is a horrible subject to talk about, but it is a fact of life. Living in denial, or simply we don't care about what we leave behind. But there are great benefits to actually planning early and having the will in place. There are tax advantages. If you do the will correctly, there are many tax advantages on that side. And I'm not going to cover tax aspect at all today. That's for a separate seminar. Planning your financial affairs. Anyone who has a financial advisor, one of the questions now they will always ask is, do you have a will in place? Vitally, vitally important. Also, as part of your planning, If your estate is over the thresholds, you can do the planning of reducing your estate, reducing the value of your estate. See your children, see your grandchildren benefit from your wealth while you're still alive. Reduce the stress on the people who you're leaving behind, your loved ones, your family. Ultimately, they're the ones who are going to have to pick up the pieces. So how can we prepare for this? We prepare for this by sorting things out beforehand, by having a document called the will. The Oxford Dictionary definition of a will, as it says on there, a document setting out a person's wishes regarding the disposal of their property after their death. In simple terms, it is your wishes. In Gujarati, it's our icha. Apne શું કરવું છે when we've passed away. What do you want to happen to your assets after you've gone? What happens if you don't make a will? Firstly, you're leaving behind a lot of stress for people, your loved ones who you are leaving behind. They're the ones who are ultimately going to have to pick up the pieces. There's uncertainty. You may have wanted to give donations to charities. You may have wanted to give donations to various relatives, nephews, nieces, whatever. None of that can happen because no one knows what your thinking was. What I see a lot of is feuds and infighting. There's a huge rise in contentions. Money is one of those areas where it is a cause for a great deal of fighting. Money drives people in the wrong way. And when they know you've died, they will try a fast one. People who you don't know, your long lost children who you don't know, come out of woodwork. People you've been associated with will come out of the woodwork after you die. Assets going into the wrong hands. You may not have wanted certain percentages to go to various parties, but if you don't have a will, you don't have a say. The probate process can become a lot longer. And all of this is leading on to the final point here, which is intestacy. Intestacy is the word used, and it's derived from the word intestate. Intestate means you've passed away without a will, and the law of intestacy kicks in. So when should you be making a will? Key times, anyone over the age of 18 can make a will, unless they're in the armed forces, etc., in high-risk areas like armed forces where they can make a will slightly earlier. The key times are buying your first property, getting married, having your first child, an absolute must at that point. And I'll come on to the reasons why. There is a myth, and I've heard this from many people before. Between husband and wife, if there are children, people will still say, it doesn't matter if we don't have a will. Everything goes to my spouse anyway, doesn't it? No, it doesn't. It depends on the size of your estate. And that's where the law of intestacy comes in. If you care for your loved ones, care for your family, avoid intestacy. This is the basic flowchart of intestacy. I'm not going to go into it in a huge amount of detail. However, two scenarios. If you are married but no children, absolutely right, everything goes to the surviving spouse. If you are married but have children, then it becomes the law of intestacy really kicks in. So the first 250,000 will go to the surviving spouse. The rest, in simple terms, is split in half going to your children, half going into a life interest trust for the surviving spouse. Now you've got to remember, is your surviving spouse going to be able to live on that money for the rest of their life? Second thing, if you have children, young children, can you imagine them inheriting at the age of 18 a large sum of money? Think about it. You've got the answer in your own head. If you don't have children and you've both passed away, first, it'll be your parents, the parents of the person who's passed away second. In a calamity situation, if it cannot be determined who has passed away second, i.e. you've died in a car crash or whatever, the younger out of the two of you is deemed to have passed away second, and everything will go down their side. So let's have a look at the actual will, the actual document, what goes in it. First, you will nominate your executors, trustees. Your funeral wishes can go in. A key area is guardianship. If you have children under the age of 18, guardianship is an absolute must. You can put gifts, donations, etc. So let me take each of these items. Executor, the role of executor is to administer the estate of the person who's passed away. And the role of the trustee is to manage any trusts which arise from the will. So you may have created a trust, or children may be young, and you may have written they will inherit at the age of 25 or whatever. So you will need a trustee to manage that. In most cases, it is the same people. The executor and the trustees generally tend to be the same people. This is a very, very important area. So those who are listening to my talk who have children, who have grandchildren, or who have children who've got their own underage minors, if they don't have a will, encourage them to do so. As it says on there, the current position is if both parents pass away before the children turn 18, which is the age of minority, and the age of 18 onwards is the age of majority, then those children become the responsibility of the court. Until the court appoints the guardian, generally, if there is no one around, most cases the kids will go into foster care, even if it's for a few weeks. A vitally, vitally important area. If you've got it documented, it's a seamless transaction almost, where the kids are going to the guardians. Funeral wishes. You can put whatever your wishes are in terms of funerals. One thing you always bear in mind is the will tends to be opened after the funeral has taken place. So it's important your executors, your loved ones, know what your wishes are anyway. This is the only part of the will which is not legally binding. Then there are gifts. You may want to give gifts to charities, gifts to friends, gifts to relatives. You may have personal chattels, items which are of sentimental value. You want to go to certain people. I get gift of pets. You may have a dog, cat, whatever. You may want that to go to a certain person. You can put all of that in the will. After all of that is done, we have what's known as the residue. So after the costs, after the gifts, whatever is remaining is called the residue. This is the value of the estate that's going to go to your beneficiaries. So this is where I'm going to come a little bit more technical now. And we've got two options here. You keep the will simple. Absolutely nothing wrong with that at all. Ultimately, in a typical family dynamic, you're seeing from me to you, husband to wife, wife to husband, and then down to the children. Children are not there, down to grandchildren. Nothing wrong with that at all. However, it is not always suited for every scenario, and particularly where wealth is quite high, it is not suited, or there are problems, i.e. there are problems, and I'll come on to that. So the next type of will is the advanced will, the use of trusts in the will. Whenever I say trusts, people always think you have to be mightily rich, mightily wealthy to have trusts. Absolutely no way. Trusts are there for protection. In most cases, I would say 80 to 90% of the cases, the main asset people have, the highest value, is their main family residence, owned by the husband and wife in most cases. And we tend to put the deceased share into the trust a lot. It's called a life interest trust or a property trust. Why? If you die young, there is a possibility you may remarry. If you remarry, you do another will which says everything goes to my surviving spouse. If you pass away, if you've got children in this marriage, there is a potential they are missing out on your share of the property. For the older amongst us, you may want to protect against future health costs, care costs. So it is a very common thing to do, putting a life interest in a will. What about the rest of the assets? We use trusts quite a lot, given a lot of them are for tax planning, a lot of them are for protection measures. Family dynamics have changed dramatically over the last 20, 25 years. The wealth has gone up. You're living in London, almost inevitably, your asset value is going to be above the inheritance tax threshold. But other dynamics have changed. Divorce rates have become higher. Children, in many cases, are not all angels. They may have come onto bad company. They may have spending habits, gambling habits, addiction habits, all the rest of it. So I do get a lot of times where parents are very concerned to say, look, how can we protect my child's inheritance? And we then come into trusts. But the first thing you must always remember, and I'm talking to this is a couple married, your first priority should be to the spouse who is surviving. Why do I say that? I ask many clients, what have you earned money for? What have you built up all these assets for all your life by working hard? You've toiled all your life. Your kids are already on the right path. They're in jobs, whatever. A common answer I get is, we want to leave everything for our children. Yes, it is an answer, but one thing, rest assured, when you've both died, everything is theirs anyway. So your first priority should be to protect financially your surviving spouse. So we have what's known as flexible life interest for those who are wealthier. Flexible life interest, in short, it's saying the person who's passed away, their assets, except the main residence, their assets is going into a life interest trust. The only beneficiary of the income of that trust is the surviving spouse for the rest of their life. Thereafter, it goes downwards into a discretionary trust. I'm not going to go into too much of the technicals on that. Use of discretionary trust. This is where there are problems. You've highlighted problems. If I'm sitting in front of you and you've highlighted a problem, that would be one of my recommendations. Why don't you put it in trust? For your child, if they're going through a divorce, if they have issues, etc. A key area is disability trusts, and I'm going to come on to that in just one moment. But also, I get a lot of call for charitable trusts, people who want to leave legacies behind. Also, people who are married but have no children, and they want to leave their estate or part of their estate into a charitable trust. We can do all of this in the will, with letters of wishes, etc. And it really, what you are doing is leaving a solid legacy behind for generations to come. Trusts are used very commonly amongst the wealthiest in our society, but now even moderate wealth, people are using trusts. So I talked earlier, a minute ago, about disability trusts, a vitally, vitally important area. Few people understand this. If you have a disabled person in your family, a child or someone you want to ensure are looked after, make sure their inheritance is protected in a protective trust for the disabled. It's nothing to do with a tax benefit. What it does do, though, is ensures that capital you're putting in the trust is used for the disabled for other things like holidays, other expenses, but is not calculated when it comes to assessment or benefits they receive from the government. Vitally important area, vulnerable persons trust or a disability trust. So what makes a valid will? A will must be signed by the testator. Testator is the person who's making the will, and at the same time of signing, it must be witnessed by two independent people, two independent witnesses. Right now, with COVID-19 going on, one of the main things I'm doing, and I've done over the 50 or so in the last 5 or 6 weeks, we are witnessing documents outside because of social distancing, etc. But it's vitally important. People who say will witness it virtually, none of that counts in the court, sadly. It's got to be physical, face-to-face witnessing. Vitally important, the person who's making the will must have sound mental capacity at the time of making their will. I remember when I qualified, one of the first things that was ingrained into me was you must have a greater mental capacity to make a will than to get married. Think about it. You're giving away everything and you must know what you're giving away. And the will must never be altered or damaged, otherwise by the court, it could be invalid. General tips on wills: make sure they're stored very safely, and if possible, register with an online portal called Certainty. Make sure the executors know where the will is kept. Make sure the original will, only the original will can be used in probate, so make sure the executors know. It goes without saying, get it drafted by a qualified professional, solicitor, will writer, etc., who are qualified with a recognized body and also carry, very, very important, also carry an indemnity insurance. Off-the-shelf wills, my advice is obviously no. Internet wills or off-the-shelf wills unless you know what you're doing. Mistakes will only come to light when it's too late. If you know what you're doing, fine. Worldwide assets. So generally all the wills we cover worldwide assets. However, professionally, my advice and most of the practitioners' advice would be if you have property, real estate in different jurisdictions, make sure you have a separate will in that country for those assets, only covering that country. Make sure it doesn't override, so the wordings have got to be very, very careful. Remember, wills can be changed and should be changed. If there is a change of circumstances, you've got to change your will. Very easy to do. Mistakes will only come to light when it's too late. Remember, it's a legally binding document. Give it the importance it deserves. Don't leave a mess behind. Leave a legacy. So always think about the end first. So the final thing is, do it now. Sometimes, and we are seeing this on a day-to-day basis with coronavirus, later never becomes. So now I'm going to move on to my next slide, which is on power of attorneys. Okay, hope everyone can see this. So lasting powers of attorney, vitally, vitally important documents in this day and age. Why? Very different from the will. Everyone will say, and I'll show you a little video right at the end of this, that we've already got a will. Why do we need a lasting power of attorney? It's to look after you while you are alive. If you fall ill, if you lose mental capacity, dementia, accident, anything like that. If you travel a lot, I get a lot of people, young people who are in senior positions, travel a lot, will always have lasting powers of attorney. We don't know what's around the corner. And if you don't prepare, we could end up in a lot of issues. So what is the lasting power of attorney? Very straightforward. Appointing someone you trust to look after your affairs, financial affairs and health affairs. So lasting powers of attorney are governed by the Mental Capacity Act 2005. They come under the Court of Protection, which is the court set up to look after the vulnerable in our society. Every lasting power of attorney is registered at the Office of the Public Guardian. It's based in Birmingham and a small office in Nottingham as well. And I'll come on to some stats, staggering stats in a moment. When they were launched in 2007, 2008, around 90,000 registrations took place. Last lot of stats available in 2018, 3.4 million registrations of power of attorneys have taken place. A staggering rise in 10 years. Started off with a small office in London. Now it's got a staff of 1,500 people based in Birmingham and Nottingham. The CEO of the Public Guardian's office, Alan Eccles, his mission is to make lasting powers of attorney as well known as driving licenses. Affordable, portable, flexible, but an absolutely essential document. Why do we need a lasting power of attorney? Well, quite simply, if you cannot make your own decisions while you're alive because of health, you want to appoint someone you trust to take control. When you lack capacity, sadly, a lot of walls start coming down. Make sure it doesn't happen to you. Quick statistics on dementia. Currently, 850,000 plus people are living with dementia in the UK. In 5 years' time, that's going to go well over 1 million. And in 20 years' time, well over 1.5 million people. Can you imagine the challenges this is having on carers, family, the society, NHS? Strokes. Currently, 1.2 million people who are stroke survivors in the UK. Not all of them lose capacity, but many of them do. Quite a substantial rise since 2006. And also a lot more young people are getting strokes. This is not just for the elderly. This is for everyone. I'm talking to everyone who's listening. Disabled people, where they've got adequate mental capacity, they understand what they're doing, but have no physical capacity or lack physical capacity, an LPA is vitally important. I encourage families who've got children who are disabled to make sure they timetable that when the children turn 18, they have an LPA in place. I have had a couple of situations in the last few years where when you turn 18, you are an adult. Sometimes parents have not been given the right to take decisions for certain things. Have an LPA and you've got that legal authority. There are two types of power of attorneys, lasting powers of attorney. There's the financial and property and the health and welfare. Both very different, although the forms will look the same. One of the questions which comes up is, I've got an enduring power of attorney, is that still valid? Yes, it is. Enduring powers of attorney stopped 2007. You can't make a new one, but it only covers financial aspects. And it can only be used when you've lost mental capacity and it's registered with the court. Hence the reason they got rid of them and lasting powers of attorney came in. Because when someone has lost capacity, they don't remember they had an enduring power of attorney. So let's have a look at the financial power of attorney. This is the power of attorney where you're giving power to the attorneys to look after any aspects of the money side, money and property, managing bank accounts, paying bills, liaising with DWP or your pension providers, selling your home. Lasting power of attorney for financial and property can be used or structured in one of two ways. Either it only comes into effect when you've lost capacity, or we keep it flexible that you can give the power whenever after registration. I always prefer the latter because it gives you the best of both worlds. Health and welfare. Who will look after your health needs? Who will be able to speak to the doctors, the nurses, the care home? Who will be able to take the final decisions if there's a life-sustaining issue? Health and welfare power of attorney can only be used when you've lost mental capacity. Up to that point, doctors are asking you questions, you are able to answer them. But it is becoming very, very prevalent now. So again, it's your insurance policy. I always consider lasting powers of attorney as your insurance policy. Why do we have a house insurance policy, life insurance policy? Because of a certain thing that may happen. Lasting power of attorney is exactly the same. Hopefully we never need to use them, but if that eventuality happens, it's too late. So the various parties to the lasting power of attorney. First, you have the donor. Donor, in this respect, is the person who's making the power of attorney. They must have adequate mental capacity to make the power of attorney, and they must be over the age of 18. If you do not have adequate mental capacity, I'm afraid it's too late, and we have to take a different route, and I'll come on to that later. So early planning, vitally important. An attorney is the second party. An attorney is not the American word for a lawyer or a solicitor. An attorney in this respect is the person you are nominating to take decisions for you in your best interest at all times. Typically, it tends to be family, your spouse, your children. If you have no one, it can be relatives, it can be friends. Ultimately, if you've got absolutely no one, you can appoint a professional. There will be charges associated to that if they are required to act. So the key word in all of this when appointing a trustee is, who do you trust to look after your affairs? Decision making. In the power of attorney, you can structure how you want to make decisions. Jointly and severally is the most common, which means all the attorneys or a single attorney can take decisions. That's the most preferred, and that gives you the most flexibility. You can do jointly, however, that comes with restrictions. What if one of the attorneys is away? What if the attorney is abroad and a decision needs to be made quickly? It's not going to work. You can have a bit of both. So there are some decisions like selling your house. You may want all attorneys to take that decision and the rest of it done jointly and severally. Or you may want spending over £5,000 to be taken by all attorneys, and the rest can be done individually. Then comes the certificate provider. A certificate provider under a power of attorney is the most important person after the donor. He's ensuring and certifying that the donor has adequate mental capacity when they've signed that power of attorney. It's usually a professional, professionals like us, solicitor or doctor. However, it can be anyone. It can be anyone who's a friend of yours who knows you over 2 years, but it cannot be your attorney and it cannot be your family. Okay? You can also have replacement or reserve attorneys. What if something happens to your main attorney? Main attorney may have passed away, lost capacity. What happens at that point? You can nominate reserve attorneys. The maximum number of attorneys available really is 4. We wouldn't recommend more than 4 at all. So you can appoint 4 main, 4 reserve, but generally it's 1 or 2 main and 1 or 2 reserves. In the power of attorneys, you also have what's known as preferences and instructions. Here, in preferences, you're giving guidance to your attorneys. So you're giving guidance to your attorneys basically on things like in health. I'm giving examples where if you're on a life support machine or you're living just on the machine, many donors write, I would prefer to pass away peacefully. I do not want to live on the machine. I want to be given only vegetarian foods, those kind of things. It's guidance. It's not 100% legally binding, but you are giving guidance to your attorneys. Legally binding instructions are in the instructions section. On the financial one, the one which we always tend to recommend putting in is allow the attorneys to appoint a discretionary fund manager or an IFA. Without this, we could end up in a situation where your attorneys cannot reinvest your money because no one will handle it because you haven't given the right in the power of attorney. So always make sure that's put in. So this is typically what a preference and instruction page will look like. Notifying others. This used to be compulsory until about 5 or 6 years ago when the Office of the Public Guardian made the decision to make it optional. So here you're notifying people other than your attorneys, you're notifying third parties that you're actually in the process of taking out a lasting power of attorney. If you've got no one, it's a good safeguard. Generally speaking, in all the ones I do, very few people use this, but it is a good safeguard if you need to use it. Why have a power of attorney? I've gone through that a little bit earlier, but really it is giving you that peace of mind that the people you trust, people you've chosen as attorneys, will be taking decisions only in your best interest at all times. And you've, rather than the court appointing someone, you have made that choice. So what happens if you do lose your mental capacity, or in Cockney language, if you lose your marbles? Unfortunately, to do a lasting power of attorney, it is too late. So we need to take a separate route, which is called a deputyship order or a court of protection order. Here, the people who may want to look after you are applying to the court to become your deputy. It can be a very long process. It's got to be done by professionals, and it's a costly process. But the worst thing about all of these court of protection orders is it comes with conditions by the court. So typically every year, the attorney or the deputy will need to submit a statement of account. What has the money been spent on for that vulnerable person? What has the income been? And if the court finds there is an anomaly, they will investigate further. So again, like I said with the wills, important to do it now. You're never too early to do a power of attorney. Anytime over the age of 18, you can do a power of attorney. Vitally, vitally important, yet, the numbers are growing, and you've seen the earlier slide, it's growing very fast, and a lot more awareness is coming out of it, but still relatively few numbers in comparison to the wills. Typical costing for a lasting power of attorney: first, there's a registration fee, which we have to pay to the court. It's currently set at £82 per power of attorney. Unless your income is under 12,000 and we provide the proof, we send off what's known as an LPA 120, and that fee is reduced half to £41. But if you're on certain benefits only, then there's a full exemption. And of course, there are drafting fees depending on who you go to. So now, coming up to the end of the presentation, I'm going to show you a short video on the power of attorney. This is an old video, but it really hits home. It's a live case. It really hits home why you need a power of attorney. Ignore the stats, ignore the fees, but just look at the content of it.
6 years ago, Heather Bateman's husband, Michael, was knocked down on a country road.
I saw him 1 minute, the next minute I saw him, he was lying on the ground. An ambulance came and he never stood up or spoke again. It was the most horrific thing.
Michael fell into a coma. They'd been married for 28 years, and as the main breadwinner, his wages paid the household bills. Had you both made plans for the future?
We'd written our wills. I assumed that would be all I would need for the rest of our lives.
But as Michael was still alive, Heather discovered she wasn't allowed to use any of his money. Heather couldn't legally have access to Michael's accounts whilst he was ill because he hadn't granted her power of attorney over his finances before the accident. With that in place, she would have had complete control over all of his money. Instead, she had to apply to the Court of Protection. That is a court set up to protect the assets of vulnerable people. Heather finally got permission to manage her husband's finances, but with very strict conditions attached.
I could never write a cheque more than £500. Our daughter had just started university and the fees were over £1,000. So I was sort of being asked to ask permission to pay my own daughter's university fees.
The system was overhauled in 2007 in an attempt to deal with the issues raised by cases like Heather's. But since then, there have been so many complaints that the system is being reviewed once again. The Ministry of Justice told us that the changes in 2007 do allow a more personalised approach and give most people who deal with the court greater flexibility over how money is spent, whilst ensuring safeguards are in place for vulnerable people. The only way to avoid this additional heartache at such a difficult time is to appoint somebody as your lasting power of attorney. But despite the government's advice that everybody should do this, only 135,000 people in England and Wales registered one in the last 2 years. That is less than 1% of the population. Lawyer Julia Avery is an expert in this field.
Lasting powers of attorney are a document you put in place now so that the right kind of decisions, the decisions you've made for yourself, can be made by someone else for you at a time when you can't do it.
To grant somebody lasting power of attorney, you need to download the forms from the Office of the Public Guardian's website, fill it in, get somebody to witness it and then pay £120 to register it. Or you could just pay a solicitor to do the whole lot for you. Having power of attorney could have saved Heather significant costs and a great deal of distress. After nearly 3 years in a coma, her husband Michael died.
I cried when Michael died, and I cried when I was released from the Court of Protection, that at last I was free. I wouldn't want anybody to go through that if they could avoid it.
So that just gives you a real perspective on the power of attorneys. And that brings to an end my presentations on wills and lasting powers of attorney. I really hope you found the information very useful. I'm now going to hand over back to the moderator, Rumit.
Thank you, Sandip. Thank you very much for that very interesting talk. Just before we get into the questions, I would like to introduce you to the panel members other than Sandip. So firstly, we have Atul Shah, who is a solicitor who ran a private practice in Harrow for over 25 years and is now a consultant solicitor. His clients range from individuals to top corporations. His approach is always with pragmatism, honesty, and service, to clients being the first and paramount consideration. He brings wealth of experience in areas which include will making, probate, powers of attorney, estate planning, social care, landlord and tenant, and court work. Secondly, we have Chetan Shah, who is a qualified solicitor with over 20 years of experience. He set up his own practice, CS Law, in 2007 in January. The firm specializes in advising both private and corporate clients in matters relating to wills, LPAs, and probate, conveyancing, litigation, asset sales and purchases, landlord and tenant matters, and matrimonial and family disputes. The firm's ethos is providing a professional service at an affordable cost. So let's kick off with the first question. The first question is for Sandip.
Yeah.
Under what circumstances should we not use the government lasting powers of attorney site?
You can use the government Office of Public Guardian site anytime you want. That's one of the options of actually downloading the forms. There are about 20 to 22 pages. If you know what you're doing, absolutely first try. A lot of my clients do that and no issues at all. If you don't know what you're doing and you get it wrong, you won't know you've got it wrong. It'll be registered, but you won't have, things like preferences, etc. You may have missed out. But nothing, no harm at all in using the government's own website.
Okay. Thank you very much,
And
Sandeep.
it will save you cost as well.
Yeah. Okay. Okay. The second question is to Chetan. Chetan, how should one structure for a will specifically for a single person with no dependents?
Okay, so the first question I would ask is, when you say no dependents, do you mean that you don't have any descendants? Because there's a difference between dependents and descendants. I'm assuming the question is targeted to say that they have no family, immediate family, wife, spouse, or children. In that case, first of all, the first thing that you need to take into account is the rules of intestacy. Who will inherit if you don't have a will? So there is a priority list of people who will inherit. And if you don't have a wife or children, the first person on the priority would be your parents. After that, it would be your siblings. If any of your siblings have passed away, it would be your nephews or nieces, and there's a whole list that goes on. Is that really what you want? The purpose of the will is to make sure that you can give your assets to whoever you want. So really, the first thing you should be doing is seeking legal advice and finding out who you should, how to prepare your will and who should inherit under the will. And it will also give you the advantage of doing estate planning.
Okay, thank you very much, Chetan. Question 3, I think this was covered by Sandeep, but perhaps a good idea to recap a little. If we have an EPA, what do we need to do to upgrade to LPA to include wellness? I think this one is for Atul, please.
Hello, good afternoon all. If you already have an enduring power of attorney, that will cover some of the financial aspects. So you need to look at the possibility of upgrading the EPA to lasting power for finances and property, and also to make a lasting power to deal with your welfare and health and care decision making. And a lasting power and an enduring power are two different creatures of law, which means that you must not assume that they have same consequences, risks, or procedures. So make sure you take proper advice and consider having lasting powers done. Now, if you decide to do that, then clearly the lasting powers will have more flexibility, will give more choices, will cover much wider boundaries for you, and at the end of the day will last even if you lose your mental capacity. So I would recommend that you consider looking into and possibly having lasting powers done, rather than just relying on a singular enduring power dealing with limited financial aspects. And that was one of the reasons why the law was introduced, to have lasting powers, and the law allowing enduring powers was repealed. It doesn't make an existing enduring power void or cancelled. It is still valid, but it is of limited effect. I hope that addresses what you are looking at.
Okay.
Thank you.
Thank you. Sandeep, a question for you.
Yeah.
How do you ascertain mental capacity?
We as professionals are very much trained in terms of looking at mental capacity, and we will be able to gauge that as soon as we start talking to a client. Do they understand what they're doing? Do they understand what I'm saying to them? Do they understand what they're giving away in terms of the wills. In terms of power of attorneys, do they understand the concept of power of attorneys? Do they understand that it's applicable only while they're alive? So mental capacity is, in majority of cases, I would say 90% of the cases is straightforward, very straightforward. Where it's on the borderline, I will be able to tell straight away that that person is not understanding what I'm saying. And we then need to go to the next step where either the doctor certifies or we get a separate mental capacity assessment done. However, where I've done cases where I know they've not got capacity, sadly, they don't pass the mental capacity test either, and we then have to go down the deputyship order.
Okay, great, thanks. Chetan, a question for you. Can anyone dispute an LPA?
Yes, the LPA can be disputed by anyone. Question is whether they have the grounds to dispute it.
Yeah.
And the main ground for dispute would be that the person did not have the mental capacity, sufficient mental capacity when they prepared the LPA, or they were influenced or put under duress to appoint the attorneys. That would be in terms of preparation of the LPA. And that's one of the reasons it's always best to seek professional advice on preparing the LPA, because the person who's prepared your LPA would have the notes when they prepared the LPA explaining what they have done, and judges are likely to take that into account. One other dispute area that could arise is that the attorneys are not doing the right thing by the person who's granted the LPA. And in that case, it would mean an application to the Office of the Public Guardian for a deputy to be appointed.
Okay, thank you. Shandip, a question for you on wills. Do wills need to declare all assets in all tax jurisdictions, or only what is in that particular jurisdiction in which you're creating the will?
So there's two types of wills, or three types. One which covers worldwide, so the will cover all assets worldwide. Like I said earlier in my presentation, if you have assets in different parts of the world, our professional advice, and I'm sure that will go with Chetan and Atul, is to have a separate will in that country. Second type of will is to only have the will covering UK, so only assets in the UK. Third type of will is a worldwide will which excludes other countries. So you've got those three options there. So you can have a tailor-made will just for UK, or excluding other countries, or have it worldwide, but then you have your separate wills in different countries.
Okay. Atul, a question for you. Can LPAs be changed, and how easy is it to do this?
Okay, LPAs can be changed, and once a lasting power is registered, we need to revoke it, and that revocation has to be registered with the Office of the Public Guardian. But when you are doing that process of revocation, I would also recommend that you consider preparing new lasting powers of attorney, so that all of that kicks in at the same time, so that you are revoking the first lasting power and then the new one kicks in. You have to get your timing right to make sure that you don't have overlap, but with guidance from a professional, you should be able to do that. In terms of expenditure, you would be looking at the cost of making new lasting powers, and maybe additionally the cost of revoking the old ones.
Okay. Thank you. Yeah, I think you've answered the second question, which is great. Thank you. The other one, if I just carry on with you on that one, do LPAs have to be renewed?
LPAs are lasting documents, which means once you make them, they will last your lifetime. All powers of attorney, including lasting powers, enduring powers, come to an end when the person passes away. But until they pass away, lasting powers continue. And that is why they are called lasting powers. They last your incapacity and they last until your lifetime. So you don't have to do anything more. You don't have to renew them. You don't have to look at anything else. There are times when you will review them to see if they still reflect your original instructions and reasons for doing them. So for example, if say the attorneys have passed away, or there is a change in the family, or your children have suddenly become over 20s, then you have to decide whether you want to leave the lasting powers as they are, or whether you want to revoke them and have new ones in place.
Mm-hmm.
But a lasting power which you are happy with will last you for your lifetime.
Okay, thank you. Question, it's a technical question. So Sandeep, basically, what type of trust is the trust for flexible life interests? Is it a bare trust? I'm not, it's fairly technical.
It's called a FLIT, or a flexible life interest trust. And technically what it's actually doing is the person who's died, so husband and wife, say the husband has died, his assets, excluding the main residence, will go into a life interest trust. The income from there will only beneficiary of that is the surviving spouse. So it's called a flexible life interest trust. Once they're both, so the only beneficiary, like I said earlier, is really looking after your surviving spouse. Once they're both died, the entire estate, except the main residence, fall into what's known as a discretionary trust for the children.
Okay, thank you. Atul bhai, just a question for you. Is there a need to have a power of attorney or lasting power of attorney for a young person age 16 that has learning difficulties?
Okay, when you talk about lasting powers, there are two things you have to qualify to have a lasting power. The first one is you must have mental capacity. And then the second qualification or requirement is you must be over the age of 18. Obviously, when then we are dealing with somebody who is under the age of 18 or doesn't have mental capacity, then the person cannot make a lasting power of attorney. Having said that, if there are issues which need to be covered, then the family can look at deputyship under the ambit of court of protection and explore that possibility.
Okay. An interesting question, I think possibly Chetan. If you need a will written in India for Indian assets, can it be written in the UK?
The answer to that technically is yes, but I think one thing you have to bear in mind, for example, solicitors, we are only authorized to advise in the jurisdiction of England and Wales. So I don't think any solicitor would be meddling around with assets outside that jurisdiction. Your best bet is to get advocates in India to write up the will so that you get the right advice for that jurisdiction.
Mm-hmm. Okay.
Can I come on to
yeah,
that?
sure.
There are qualified professionals who will write Indian wills only in the UK. I only know one or two of them, but there are.
Okay. And one very simple question whilst you're on, Sandhu. Lasting powers of attorney have to be for each person, so husband and wife. So you must have two separate lasting powers of attorney for each individual person, is fine, right?
Correct. Correct.
Okay. And I think you went through this. You have to register the LPA, and it can't be part of the will. It's a separate document, correct?
Separate document. Without registration, it's not worth the paper it's written on. So it's got to be registered, stamped, given the LPA number by the Office of the Public Guardian. Registration process is about 2.5 months. So absolutely, it's got to go through it's a deed. It's a legal deed, so it's got to go through the entire process.
Okay. And maybe a question, this if I direct it to Chetan, please. Chetan, where you have preferences and instructions in the LPA as regards finance and property, and if they haven't mentioned any preferences or instructions, can the attorneys appoint fund managers without this being specifically mentioned?
Yes, they can, because they have the attorney has the right to do whatever the actual person would do, and they're stepping into their shoes. So yes, they can do that.
Right. And
Rumit, can I intervene on that one?
Please.
I've had a case recently where one of the large financial institutions has refused because it wasn't on the LPA.
Okay.
All right.
So
I see.
it's just, it used to be, no one used to put it in years ago. It's now de rigueur to put it in most of the LPAs. Whether you use it or not, it doesn't matter. But there are some companies, some financial institutions who don't, because they think the attorney might be abusing their power
Right.
and protecting themselves.
Sure. Sure. And in terms of wills don't have to be registered, correct?
There's no official registration in the UK for wills. We do recommend registration of where they're stored, etc., on an online portal called Certainty, but there is no official registration. Like India, there's a registration. In the UK, there's no registration. Your last will is your last testament. Yeah.
Okay. And the follow-up to the question before about whether, the preferences don't state having an appointment of a fund manager, in which case, can we amend, should the LPA be amended, or should a new one be created in the event that that has to be added in?
Is that to me?
Yeah.
Okay, so once an LPA is registered, you can't amend an LPA.
Yeah.
Okay, so even you can't add a separate preference or whatever, you need to do a new LPA.
Okay, so it's just going through the whole process again.
Yeah.
Okay, sorry, I'm just going through different questions which are coming in. Sorry, just bear with me 1 second. Yeah, you've just answered one question which somebody put in again, so that's fine. Okay, I think most questions have been answered. If there's a worldwide will which has been written in the UK, presumably that overrides all the wills in the other individual countries?
Yes. Typically, yes, but that's why I said if you have assets in a different country, the will you do in that country has got to specify it's only applicable to, say, India or whatever. If there is a worldwide will, it's not the end of the world, but the probate process is going to be horrendously long to reseal that will in a different country and then to release those assets. I've known, in fact, we're dealing with a case where the probate process is now 5th year and it still hasn't been completed.
And I think another question which has just come in, can an overseas resident be an executor of a will?
Yes. Simple answer, yes.
Yeah, no, that's great. Sorry, I'm just trying to understand the question here. Yeah, the question is, the question is basically somebody's been ill, even having suggested making a will, but haven't done so. And it is, as long as the mental capacity is there, presumably they should make a will as soon as possible.
The answer to that is yes, but just looking at the question, it's saying that the person, despite having been told a number of times to make the will, hasn't really done it.
Yeah.
The only person who can give instructions on the making of the will is the person who needs to make the will. So really, if they're not going to make the will or don't want to make the will, then there's very little you can do about it.
Is there a gentle way of asking them to start the will writing process?
Show them Shandip's presentation and show them what's going to happen if they don't make the will.
Yes,
that generally does wake up people, to be honest. What will happen if they haven't made a will, or how much of the assets are going to go to in terms of tax. So that generally does wake up people.
There's a strange, it's a question here, is can an attorney acting under an LPA make substantial gifts? So I presume if there is an LPA, somebody who's an attorney, can they make gifts to the siblings of the person, I presume? That was the question.
Not technically, no. An LPA, and Atul, you'll be able to correct me if I'm wrong,
please.
but gifts are really not allowed, even gifts to charities. What you are doing is you are acting in the best interest of the donor at all times. Okay? So you can't say, you can't do the inheritance tax planning and start giving stuff away and all the rest of it, unless there's written instructions that, look, I want to give so-and-so money to so-and-so people on their birthdays or whatever. If that's what the donor would have done, yes, but otherwise, no go.
Let me add to that.
Please.
When you do a lasting power, you are asking the attorney to make decisions. So the attorney needs to understand the requirements of the donor, the person making the power, which means that if the donor hasn't made those instructions clear or wishes clear, the attorney will have difficulty to show that this is what the donor would have done, especially when it comes to giving away assets.
Yeah.
So it would be wise to introduce the idea in the preferences instructions page in some way to make sure that the attorney is made aware of what the donor would have done, which includes giving away gifts, donations, whatever they have in mind. And it would be dangerous for an attorney to give away or do things which he cannot or she cannot prove that this is what the donor would have done. So you need to look at backing the power in a very wider context, take proper instructions, give proper instructions to the person making the power for you to make sure that anything that you have in mind is addressed in the power, and make use of the preferences and instructions area of the power to express yourself well.
Absolutely.
Yeah. Perhaps this one is one for Atul, because I think he answered one before on disabled people in the family. So when you have a disabled person in the family, to ensure their safety on a financial basis, can you choose members outside of the family as trustees or executors or attorneys? And is there an age limit for that?
Okay, now whether you make a will or you make a lasting power of attorney, you need somebody to do the work for you, to act for you, whether it's an executor, trustee, or an attorney. And the choice of that person is important to make sure that they carry out what is required. The executor or the attorney must be over the age of 18. And in the case of wills, executors cannot benefit from the will. So you have to be careful how much in detail you go to. You need to discuss this with the person who's going to advise you when making the will. But with a lasting power, it is slightly different in the sense that it can be anyone over the age of 18, as long as the attorney knows what is required. Attorneys can be related to you or not. And attorneys can be singular, so you can have one attorney, or it can be a number of attorneys. And it doesn't matter whether the person is disabled or not, as long as the person is able to make a power. So that they need to be over the age of 18 and need to have mental capacity when they make the power.
Thank you.
Hopefully that answers the question that was put.
Chetan, very quick question for you. What are the liabilities of an attorney?
The attorney has to do what is in the best interest of the person who's made the power of attorney. So if they do anything that is fraudulent or do the wrong thing, then they would be personally liable.
Right. Okay. Sandeep, I think this might have been covered before, but can you revoke an LPA that was arranged?
Yep. Answer is yes. You can revoke the LPA anytime by sending it back to the Office of the Public Guardian. The donor can revoke it as long as they've got adequate mental capacity. Yeah.
There's a question here. Sorry, I'm conscious of time as well. Would you recommend to attorneys to learn the profile and the likes and dislikes of the donor to be able to execute the wishes of the donor, which then are also addressed by the consultants in the letter of wishes. Shandip probably is starting point with you.
So in most cases, the attorneys tend to be their own family anyway. I would say in the cases I do, tends to be their own children. So yes, understand what your parents are, what their wishes are. So you can talk to consultants accordingly. Put it in the preferences. You can do an advanced directive as well. This is called a living will, but that's not done that often. But yes, absolutely, you've got to know the person, the donor. I'm assuming this question is coming from the health angle. So yes, but for the donor to write it in the preferences is a good way.
Okay, great. Atul, just quickly, can executors, this might have again gone through in the presentation, but can executors, they can't be beneficiaries in a will, can they?
Yes, they can.
They can be. They can be. But when you are dealing with the choice of executors, you need to look at whether they should be separate from beneficiaries. If it is children, if it is brothers, sisters, or parents, it's fine, because that's where the source or where you would look at to have executors. But as soon as you start looking at somebody else, make sure you are happy with the choice of executors. But legally, executors can benefit from the will as beneficiaries. But we tend to make sure when we advise, we have to ask the question, should the executor should also be the beneficiary or not?
If I can just add to that, one of the questions to ask yourselves is, let's say you appoint your children as executors. Do the children get on with each other? Because the last thing you want is infighting amongst your own executors and bringing everything to a halt. The whole purpose of appointing executors and trustees is these are people you trust. So just bear that in mind.
Okay. I think I'm going to take one last get copy. Here we go. No, I think we've answered literally all of the questions, which is excellent. I hope we have. In case I miss them, I really do apologize. But before we wind up, can I say a very, very big thank you to Shandip, Atul, and Jatan for their fantastic question answer, and also for the fantastic presentation by Shandip. Thank you so much for doing this at such short notice. Now, just before I finish off, I just wanted to share a couple of slides, if I may, if my slide thing works. Yeah, let me just go down. So just to let you know, as I mentioned before, we are also trying to help the elderly and the vulnerable and the isolated and the key workers. And this is our helpline poster. So if anybody does need help, please phone the number and we'll try and help you. Secondly, if there are any further questions we may not have answered, or you have further questions and request information, then please ring this number. This is our individual and business support helpline. And finally, what we will be doing is, obviously, we will circulate this number, and we will have the whole presentation. It's recorded, so it'll be on YouTube. And we will make sure that all the attendees today will get an email with the link and the helpline number. So please, I know a lot of people on the chat were asking where this is going to be. It'll just take us a couple of days. So please bear with us, and we'll try and get that to you. And the next session, as you may already have registered, or if you haven't, please do. It's on Wednesday, the 6th of May at 7:30 p.m. And it's on mortgages and insurance protection by Ashit Shah. So that's going to be a very interesting in the current climate as well. So please join us then, and we'll be very happy to welcome you all. Finally, if you have any other suggestions for topics for the webinars, please let us know, and we'll see if we can try and do a webinar on that. But thank you very much indeed. That's it. So all I need to say is be safe, stay at home, protect the NHS, and save lives. Goodbye.